Warning, censorship. Warning, censorship.
You should have your proverbial day in court. You're innocent until proven guilty. That's the system. Why did the Supremes give lenience to such a ominous system in the first place?
Well, the way they viewed it was that it's essentially just an administrative fee. There are no penal consequences, and it's not criminal in nature, and that was essentially the test. So because it is an administrative penalty, they want it to be easier to collect and take the resources away from having to use it up in court. So less bylaw officers' requirements in court, less court resources to be used, etc. Makes things a lot easier for them to generate that revenue, which is the entire purpose of this. It's really insane, and the fact that there's no actual impartial adjudicator, it's just somebody sitting in a cubicle, a city contractor, essentially at both levels of both the hearing and the appeal stage. It absolutely does sound like a conflict, and I think their mandate is extremely clear, and that's to collect money.
So the other day, via email, I received a whopping $560 ticket from Hamilton bylaw enforcement officer Ranjani R.J. Reddy, she, her. You see, the poobahs in Hamilton, they don't care for non-mainstream media practicing journalism in Steeltown, so out come the ticket books, with the ostensible violation reason being a lack of social distancing. Yeah, right. But that's only part of the story, folks. The other part of the story is the type of ticket I received. It's called an Administrative Monetary Penalty System ticket, or AMPS for short. And this is a very ominous ticket indeed, given that the recipient of such a ticket is extremely limited when it comes to fighting the ticket. Indeed, you can't tell it to the judge, as the saying goes, because when it comes to an administrative monetary penalty system ticket, there is no judge, there is no jury. In fact, there is no court. Instead, to seek a modicum of justice, one has to make a plea to the very same people that issued the ticket in the first place. But how can this be? Joining me now to shed some light on that which is known as the Administrative Monetary Penalty System ticket is our superb paralegal, Jenna Little. Good day to you, Jenna.
Hey, David. Thanks for having me.
Thank you for joining me. So, Jenna, when I first received my AMPS ticket and discovered there's no real way in which to fight it, I thought, this can't be a thing, because it seems to me that, as they say in Vegas, the fix is in. So, Jenna, please explain to me, how did such a thing ever come into being in the first place?
Well, it started with parking tickets. Back in 2015, there was a Supreme Court ruling called Guiden v. Canada, and it was a tax issue where somebody was owing over $500,000 in administrative monetary penalties. And so obviously they fought this. It got all the way to the Supreme Court, and they lost. And they essentially determined that Section 11 of the Charter doesn't apply to administrative monetary penalties because they're not penal or criminal in nature. So that allowed municipalities to start implementing these AMPs for all sorts of things. Parking tickets was how it began. And now that we've got the Reopening Act, they've created new bylaws in many different municipalities to enforce these through AMPs as well.
And Jenna, which municipality did this begin in the first place?
I'm not sure where this began. There's a handful of municipalities that have adopted it. So Toronto, I would say Toronto was probably one of the first, if not the first. And they started with their parking tickets. Hamilton has also adopted it, and a few cities within York region have adopted it. Mississauga has as well.
You know, that is interesting. But what you're saying is that this did indeed survive a Supreme Court challenge, and this, makes me curious, because surely, regardless of what you're getting a ticket for, what the amount is for, you should have your proverbial day in court. You're innocent until proven guilty. That's the system. Why did the Supremes give lenience to such a ominous system in the first place?
Well, the way they viewed it was that it's essentially just an administrative fee. There are no penal consequences, and it's not criminal in nature, and that was essentially the test. So because it is an administrative penalty, they want it to be easier to collect and take the resources away from having to use it up in court. So less bylaw officers' requirements in court, less court resources to be used, etc. Makes things a lot easier for them to generate that revenue, which is the entire purpose of this.
Yeah, it's easier and more efficient, but I question, Jenna, where is the justice? And when I look at the ticket I got in Hamilton, for example, $560, to me, that's a lot of money. I think to the average person, that's a lot of money. When I reached out to the bylaw enforcement officer, she said you can basically plead, for some lenience to the same department that issued me the ticket and appeal, I think, to the same department. That's crazy. That, to me, Jenna, is an inherent conflict of interest.
Yeah, it's really insane. And the fact that there's no actual impartial adjudicator, it's just somebody sitting in a cubicle, a city contractor, essentially at both levels of both the hearing and the appeal stage. It absolutely does sound like a conflict, and I think their mandate is extremely clear, and that's to collect money and to create some sort of deterrence for people.
Yeah, and I mean, it brings into, I guess what I'm getting at is the potential for abuse. In our case, I don't like the kind of politics Rebel News is involved with. I don't like that particular person on camera. I'm not going to give any kind of, even if I had a valid case. That's what I'm worried about. But tell me, Jenna, it's gone before the Supreme Court. Is there any possibility to bring this ticketing system back before the Supremes? Or is there a whole, I guess, process which would you would have to go through in order to have it re-examined?
I think that it's a long shot, to be honest with you. I think it's been fought and it's lost. And to make matters worse, back in 2015, the government actually wanted to impose these types of administrative monetary penalties to traffic tickets.
Wow.
So traffic tickets with demerit points that affect insurance and sometimes come with some pretty severe monetary penalties could go through the system without even having to go in front of a justice of the peace or even review disclosure, because that right also doesn't exist under the AMP system.
Well, that to me is outrageous, because you should have your day in court with traffic tickets for sure. And I would imagine there would be great employment loss when I look at the paralegal profession, of which you are part of. I mean, a lot of paralegals are specifically assigned to traffic tickets, are they not?
Yeah, absolutely. It's our bread and butter as an industry. The whole quasi-criminal realm is full of paralegals who practice specifically in that. And that's why I'm extremely thankful for the seniors in our industry who stood up in 2015. The Law Society fought against the AMPS change as well. And then once that failed, the Ontario Paralegal Association got in and intervened as well. And they were able to conquer this and avoid this mess from happening. So I have to give a huge kudos to all the senior paralegals in our industry who took this, nipped it in the bud from the very beginning in 2015.
Well, Jenna, I think this is something we should keep a keen eye on. For myself, I think it is outrageous that my colleague Efren received tickets for shaking hands in the sum of $560, and you can't, it's almost like the farmer who got robbed of chickens from the hen house the night before goes to the den of foxes where the chickens are and pleads for leniency. It's like I said, it's an inherent conflict of interest. I guess what we need to do, I guess it's part of our lives now in certain ticket writing realms. I guess we have to keep a keen eye that it doesn't spread like they tried to make it spread into traffic tickets. Last word goes to you, my friend.
Well, I think the thing that I'm really concerned about as well is that we've got a multi-level approach that people can be targeted for any reason under the Reopening Ontario Act. So you can be given an administrative monetary penalty by way of a bylaw. You can be given a ticket that's $880, the same amount, but you get to go to court. And then you can be given a summons, which minimum fine could be $5,000, depending on what you're charged with. So it's just they're coming at us from all angles, and this administrative monetary penalty is just the icing on their cake.
I agree. I think this AMPS is totally alien, that is, Jenna, to the kind of system of law that we have in place. The idea that you can't plead your case. It is shameful this was thought of in the first place, and I think it's doubly shameful that the Supremes are giving this a clear passage. Let's just hope in the future it doesn't spread to any other realm, because this is, in my opinion, despicable. Jenna, thank you so much for your insight, as always.
Thank you so much for having me, David. It was great chatting.
Likewise. You take care.
Thanks. You too.
Can you believe it? Getting a ticket that you can't fight in court? Well, that's what an AMPS ticket is. And I have one from Hamilton Bylaw for $560. We have to fight this. If you can, please help me out with my legal fees. Go to standwithmenzies.com. That's standwithmenzies.com. And if you're able to, kindly make a donation. Thank you.